Okay, thank you.
So welcome to panel 5, which will focus more specifically on how courts and tribunals can shape reparations. And Armando, who is one of our fellow organizers, is with us, joining from Lisbon. So he will be really moderating the debate. Let me just say that we will have 4 very interesting and hopefully also speaking to each other presentations, focusing on the role of courts. So maybe Armando, I can just very briefly introduce the speakers here, or if you want to do that. But we have Lucas Carlos Lima, who is professor at the Federal University of Minas Gerais, joining us. We have Loeva Georges, legal counsel at Wildlife Justice Commission. Hazhar Jamali, postdoctoral researcher at the Law Faculty of University of Zurich. And together with us here in person, we have Mirto Leibadaru, PhD candidate at McGill University Faculty of Law. You can see in the program the titles of their presentations. So without further ado, Lucas, you have the floor. And I think, Armando, if you want to say a few introductory words before that, or if not, you can just comment and jump on with questions to everybody. Lucas, you have the floor.
So thank you very much, Vladislav, and thank you very much, Armando, and all the organizers for this fantastic opportunity. I've been following online the discussions. I will do with some topics that we already discussed, but I'm very happy to be here with you in this morning directly from Minas Gerais, Brazil. So I'm talking about the Inter-American Court of Human Rights and what's happening right now before the court while we attend advisory opinion. And this new recognition of the rights to a healthy environment as a judiciable enforceable right under Article 26 of the American Convention on Human Rights has opened a new frontier for the Inter-American Court of Human Rights. That is the question of reparations in the context of environmental damage and therefore even indirectly in situations related to climate change. While several regions and international courts have addressed climate-related issues from a human rights perspective, the inter-American system remains unique in both its broad remedial powers and its proactive engagement with environmental matters, not without some resistance and dissenting votes. This presentation explores essentially the role that the Inter-American Court can have to provide meaningful remedies for communities disproportionately affected by climate harm, drawing on its robust reparations jurisprudence and recent developments on case law, especially in the light of the advisory opinion. While there is not yet direct practice related to climate change litigation before the Inter-American Court, one can speculate about the consequences that this case law, given the recent development on the relationship between the protection of human rights and environment before the court. My idea here is to identify some of the problems, and therefore I would like very much some input and reaction from you, especially for the final paper, either on the Q&A and or via email or other sources of communication. So I will start with the reparatory function of the Inter-American Court. The court has long recognized the principle that every human right violation gives rise to the obligation of full reparation. Anchored in the Article 63 of the Convention, the court's remedial mandate has evolved from a traditional framework, forms of redress, such as compensation and cessation, to an expansive framework encompassing symbolic measures, institutional reforms, and structural remedies aimed at societal transformation. In landmarks cases like Alabotoe versus Suriname, Plan de Sanchez versus Guatemala, and more recently, La Oroya versus Peru, the court has crafted complex reparation orders involving community-based healthcare, infrastructure development, environmental rehabilitation, and public acknowledgement of wrongdoing. In the recent case law involving the violation of the right to health environment, especially the 3 cases from last year, the court ordered the direct mitigation of the environmental harm caused by actions or omissions by states. This rich case law is grounded in the general law of international responsibility, particularly on ARSUA, which the court has quoted and applied systematically, perhaps with some diversions. However, one can even perhaps identify an emerging lex specialis regime of secondary rules of reparation, particularly developed in the court's case law. The principle of full reparation, restitution, compensation, satisfaction, guarantees of non-repetition, and rehabilitation form the backbone of the court's reparatory logic. Notably, in cases that involve environmental degradation, the court has already demanded restoration of ecosystems, adoption of environmental recovery plans, and community participation, design, and implementation. Article 26 of the Convention, which guarantees the progressive realization of economic, social, and cultural rights, has been interpreted by the court to include the autonomous right to a healthy environment. The protection of the climate system is considered by the court as one of the material components of such right. The court has observed that states have the obligation to regulate activities that cause significant environmental harm and to mitigate necessary negative impacts that could not be avoided. The duty to prevent environmental harm also encompasses transboundary damage, and here we enter the question of extraterritorial jurisdiction. In this regard, states may be held responsible for significant harm caused to individuals beyond their borders by activities originating within their territory or under their authority or effective control. The court's decision in Nuestra Tierra versus Argentina, 2021, La Oroya versus Peru, 2023, constitutes this turning point regarding not only reinforcing the enforceability of these rights, but also ordering a set of reparatory measures that integrate environmental science, environmental justice, participatory governance, and social accountability. This judgment signals the court's willingness to treat environmental harm not merely as an indirect violation of other rights, such as the right to life, but as injuries to environmental legal interests. In the recent case of Uwa indigenous people versus Colombia, 2024, the court, among other violations, determined that the explosion of an oil pipeline was damage to the rights to a healthy environment, and the court said, and I quote, Colombia shall adopt measures to mitigate the environmental damages caused by the blasting of the Caño Limón Convenience oil pipeline in 2014. In compliance with this measure, the state shall inform the court about environmental impacts caused by the blasting of the pipeline and actions taken to mitigate the environmental damages. Likewise, it must inform on the actions that will be implemented to mitigate the environmental damage generated by the oil spill and any other environmental damages. End of quote. As can be observed, as environmental cases increasingly enter the docket of the Inter-American Court and the issue of reparation of the harm caused begins to emerge, the court starts to develop specific reparation techniques that involve not only compensation, but damage monitoring and legislative adjustments of states to meet the material and procedural requirements imposed by the right of a healthy environment. Climate change presents a qualitatively different challenge, though. In its diffuse and transboundary nature, coupled with slow onset of disproportionate impacts, complicates the causal and evidentiary standards that the court has developed so far. But the court has already developed tools that may prove useful in this context. The situation is enriched by the fact that we have the advisory opinion on climate emergency and human rights to be expected in the next months. In the written submissions pending before the advisory opinion, some states and several members of the civil society have raised the question of reparations. While the court is not expected to pronounce on specific cases, the opinion could clarify key normative parameters, such as the applicability of Article 63 to these occasions, how the relevance of the common but differentiated responsibilities and capabilities, which was raised by almost all states, plays a role in these questions, and types of reparation that may be required under the inter-American law. Some states have even emphasized the need to climate reparations to reflect historical emissions and capacity to act, while others argue for a uniform standard of diligence. Civil society submissions, in general, we had more than 200, have pointed to the precedent value of past reparations orders and the need to develop green remedies tailored to the complexities of climate harm. Let's now transpose all these environmental standards to the idea of climate harm and climate reparations. So we can just say that these standards recognized in these 5 cases, Nuestra Tierra, La Oroya, Uvo Indigenous Peoples, Tagani, Taranome, and Raman Creole Peoples, 2024, all the last 3, inform future remedies for climate situations or climate-related violations of the convention. I managed to, analyzing this case law, identify at least 4 key findings that I would like to share with you. First, the question of restitution of environmental remedies. While full ecological restitution is rarely possible in climate cases, the logic of ecosystem restoration and rehabilitation already accepted by the court can be applied to climate harm. In La Oroya, the court ordered the Peruvian states to conduct a comprehensive environmental diagnosis and implement a plan of action with the participation of affected communities. A similar approach could be deployed in climate reparation cases, particularly for communities experiencing sea level rise, desertification, or climate-related disasters. 2, compensation and financial redress. In several environmental and indigenous right cases, the court has awarded compensation not only for material loss, but also for moral damages and communal suffering. The qualification of climate change presents difficulties, of course, but nonetheless, the court has already dealt with analogous challenges in cases involving displacement, pollution, and health impacts. Climate compensation could therefore be structured around similar parameters, with state liability grounded in a combination of contributory emissions and failure to implement adaptation measures. Naturally, jurisdictional limits of the court will be imposed here. Third, satisfaction, non-repetition, and symbolic measures. Perhaps the most adaptable category, satisfaction includes official apologies, public ceremonies, and educational and cultural programs. These remedies have often been used to acknowledge the historical suffering of marginalized groups, including indigenous and Afro-descendant communities, which dialogues with the former panel. And in this context of climate change, symbolic reparations may play a crucial role in restoring some dignity to the frontline communities and recognizing the ecological losses they suffer. Fourth, and the most perhaps more unclear form of reparation are the climate-related reparations. But it's least conceivable that once climate change-related cases reach the Inter-American Court after passing through the scrutiny of the Commission, the court will have the opportunity to directly address issues of mitigation and adaptation, potentially even suggesting the adaptation of domestic legal systems to the international obligations already undertaken. This area is naturally the most uncertain so far, given the absence of practice. Challenges and opportunities, and here I go to my conclusions to respect my time. Adapting the Inter-American Court's reparatory framework to climate change is not without obstacles. Issues of attribution, causality, and transborder harm complicate the application of the traditional legal standards, even for the Inter-American Court. Moreover, the scale of climate reparations may exceed the institutional and financial capacities either from the court, experts, proof, and other issues to be discussed, but also the states involved. Still, these are no reasons for inaction. On the contrary, they reinforce the need for a creative and principled approach that combines legal innovation with procedural pragmatism. A case-by-case approach would probably be followed by the court by the climate-related arguments raised by the parties, and will probably be an additional request the parties will advance as reparations. In this sense, Article 2 of the Convention can be particularly useful as to the adoption of domestic legislation and adoption of national measures. One opportunity lies in the recognition of collective and intergenerational rights. The court has already recognized collective victims in environmental and indigenous peoples cases, and noting that the American Convention precludes it from doing so, and nothing precludes that it does the same with the American Convention. Similarly, reparations aimed at future generations through educational, institutional reform, and ecosystem restorations may fall within the logic of satisfaction and non-repetition already used by the court. So, in conclusion, the Inter-American Court of Human Rights is uniquely positioned to advance the conversation on climate reparations. Its expansive remedial powers, progressive jurisprudence, and the history of structural orders make it fertile ground to reimagine justice in the Anthropocene. by drawing on its existing framework for environmental and human rights violations, and by incorporation the voices and demands emerging from this advisory process, the court can play a central role in shaping a regional and perhaps even global response to climate justice. Thank you very much.
And thank you very much, Lucas. It's not a coincidence that you come from Brazil, meaning a country where courts have been saying that climate litigation needs to be autonomous in terms of process and methodology with respect to or in relation to environmental litigation. And it's not a coincidence that you come from what in the past we would say the New World, meaning a place in our geography where you have an enhanced understanding of the idea that law is not a fossilized reality. And so if it doesn't work, let's just change it. And you emphasized quite well how the Inter-American Court on Human Rights has this different manner of understanding or viewing climate damage. What will be important to discuss afterwards is what are the limits of this, and especially if this human rights understanding of climate compensation reparation should have a certain impact outside the system of human rights. A good example is precisely the La Roya case, which you mentioned, where in fact there was a very enhanced understanding of human rights obligations, but suddenly the Peruvian state has an arbitration in which the investor invokes precisely the opposite. Now we have as a second intervention, Loeva Georges. In case I'm mispronouncing your name, please correct me. So Loeva, the floor is yours.
Thank you very much for the introduction. So yeah, my name is Loeva George, and I am legal counsel at the Wildlife Justice Commission, but today I will present in my own capacity. So my presentation focuses on reparation frameworks under international law, some of which have been probably already dealt with in part, or the main topic of other presentations. But I will look at specifically some of the international legal frameworks to address environmental reparation under international law beyond the state responsibility framework. And so it won't look at climate reparation specifically, but environmental damage and reparation more broadly. Let's start with looking at state responsibility. So state responsibility is the traditional avenue to address environmental damage under public international law. So it works with holding a state responsible for environmental damage if that environmental damage is linked to a breach of an international obligation by that state. So that's actually one of the limits of this framework, is that you have to prove that there's a link, a causal link between the breach of an international obligation and the environmental damage. And that can be quite difficult in the case of environmental damages, and especially in the case of climate change, when that link can be quite complex. So that's why I believe it's relevant to look at alternative approaches to reparation. And so I've identified three alternative approaches outside of the boundaries of state responsibility. There are, of course, other approaches, so this is not an exhaustive list. So we'll look at each of them and highlight their merits and potential limitations to address environmental damage. The first one we'll look at is risk allocation under strict liability regimes. In that context, strict liability regimes refer to mechanisms created under international treaties to allocate risks connected to the conduct of certain hazardous activities and to provide compensation for damages that may occur as a result of that activity. So it is referred to as strict or objective form of liability, because it doesn't require to prove fault, so the breach of an international obligation, for example, to trigger the duty to repair. So this is one of the advantages of this approach. Another advantage is that through those strict liability regimes, the operator of the hazardous activity is held liable in case of damage, irrespective of whether they cause harm. It's connected to a breach or something like that. And that means that this places the environmental cost of certain activities on the polluters, which may deter pollution, for example. And that can also enable to catch the activities of private entities which would not be caught by state responsibility. These regimes have some limitations. However, they only focus on providing financial compensation, which may not always be the most appropriate remedy for environmental degradation or climate change. They only cover certain hazardous activities for which a strict liability regime in the form of a treaty or provision have been adopted, such as an oil spill, for example, but it wouldn't cover, for example, drought that have been intensified by climate change, because there's no strict liability regimes on this. They've been largely left unused, except for the oil transportation liability regime, so that's a big limit. And they only provide reparation when the damages also affects natural or legal persons, and not when they only affect the environment as such. Now we'll move to the second approach, alternative approach to reparation. This is international cooperation through ad hoc remediation arrangements. So we can refer to ad hoc remediation arrangements as agreements or institutions that have been established by states on a case-by-case basis to deal with particular cases of environmental damage. Those are not generalist framework, but I think they might be interesting to look at and to see what we can learn from them and to what extent they can be replicated. So 3 of those are bilateral compensation agreements, post-conflict reparation institutions, and international reparation funds. So to my knowledge, the 2 first ones have not been used in the case of climate reparations. While the third one has been used, so that's why I will focus on the last one, so international reparation funds. International reparation funds are pool of money to which states may contribute and that is made available for reparation. They can be linked to a specific situation or be of general scope. One example of such fund is the International Oil Pollution Compensation Fund. One of the advantages of this approach is that it addresses the issue of the lack of funding, which is often one of the main obstacles to environmental reparation. And it can also address the root causes of the environmental damage if when it's financed by the profits of the polluting or emitting industry. That's the case of the oil and the International Oil Pollution Fund. However, some of the limitations is that, like the strict liability regimes, it only provides financial compensation, and this approach, international reparation funds or other ad hoc agreements, are highly dependent on circumstantial factors such as political context or the willingness of states. So in the case of climate change, the UNF CCC, Conference of Parties has established various funds that have been dealt with in other presentation during this workshop. That includes the Special Climate Change Fund or the Adaptation Fund. And I believe the next panel will go further into details on this. So yeah, they will probably highlight some of the advantages or shortcomings of those funds. So I won't go into further detail on this. The third approach I wanted to talk about is the promotion of treaty compliance through non-compliance procedures under multilateral environmental agreements. So those are procedures that have been created by parties to a multilateral environmental agreements to implement their treaty obligations and promote compliance with them. They're designed not to only sanction the breach of an international obligation, but also to promote compliance. So that means they adopt a facilitative approach in that in the case, for example, where non-compliance is not connected to a lack of capacity, they will allow for a direct support to be provided, and such as financial assistance or technical expertise, and that will allow for the non-compliant conduct to be brought back into compliant conduct. This is the focus of this approach, and that can also be a limit of that approach to reparation, because it is as such not specifically designed to provide a remedy, but to bring the conduct back into a compliant conduct. It is also not usually doesn't have it is not binding as such, and it only concerns some treaty obligations where under which there are active non-compliance procedures. So that's the case of the Paris Agreement, for example, under which states have agreed to nationally determined contributions, which I'm sure you're also quite familiar with this non-compliance procedures. So yeah, there are merits, there are disadvantages to this approach to environmental reparation, like the other approaches. So to conclude, we've seen that there's diversity of approaches to environmental reparation beyond the state's responsibility regime. We looked at existing mechanisms that focus respectively on risk allocation, international cooperation on an ad hoc basis, and the promotion of compliance with treaty obligations. So each of these approaches have potential and limitations to addressing environmental damage, and it can be argued that they should be probably used a bit more or like expanded upon because they have a certain potential. And what is relevant to mention is that, of course, they've been presented here separately, but they can be used together to better provide more effective remedy for environmental damage, and in our case, climate reparations. So there's like a complementarity element to it. This is all I had for today. So thank you very much for your attention. I look forward to discussing.
Thank you very much, Loeva. You presented a very comprehensive study on different solutions that may depend on new treaty amendments or something like that, but not necessarily. The case of non-compliance is a good example in which non-compliance mechanisms under the Paris Agreement have been able to navigate through the waters and to enhance their position. And the new ETF is a very, very good proof of that. You were very honest also in showing the limitations of your alternative solutions, but still I would say with a positive note that one thing when I was reading your abstract that I was thinking to myself is that if we are creative enough and if we try to look elsewhere and to think outside the box and the traditional frameworks in which we have been discussing these ideas of state responsibility for climate damage, perhaps we may find a better solution in terms of treaty design that may be adopted. Perhaps we can target directly private operators, as in the case of strict liability regimes. Perhaps we may find a solution which is more amenable to developed and developing states. We don't know. So creativity perhaps could be our main key to navigate through. Then we have Hazhar Jamali. Once again, if I mispronounce your name, I'm quite sure I did it. In my defense, in my own language, I mispronounce names. So I'll ask you to correct me if that was the case, and the floor is yours.
Thank you so much, and thank you for pronouncing my name also correctly. This is quite good. It's honestly quite a difficult name, so it's not so easy to pronounce my name. In any case, I'm very, very thankful to the organizer of this conference for inviting me also to this event. While I'm not there in person in Canada, but it is still my pleasure to be with you online. And I know that it is already late for those who are attending the conference in person. It's almost lunchtime, so I also try to keep my presentation within the time limit that we have. And so within the scope of my presentation, I will discuss the notion of success in climate litigation, and I will reflect on the judgment of the European Court of Human Rights in Lima Senioren judgment, or Lima Senioren case. I discuss this notion of success in climate change litigation because often I see it is overlooked in academic literature. Since the agenda judgment, we have so many climate change litigations. In so many cases, applicants and litigants, they have succeeded to secure legal victories at the courtrooms, and sometimes also defeat. And then immediately after that, we hear a lot of remarks by scholars discussing the success and failure in climate change litigation when a case is lost or won. So against this backdrop, I will discuss what we should consider when we are discussing the notion of success in climate change litigation, because success in itself is very complicated notion, and it requires us to consider different factors that I will explain throughout my presentation. From what I see, legal victories for me is not equivalent to success, nor does legal defeat is equivalent to failure. And to better understand the notion of success, I believe that we should take into account the broader socio-political impact of a case, regardless of the fact whether a case is being successful or not at the courtroom. I think to illustrate this point, the decision of the German Constitutional Court in Neubauer case is an excellent feat for us. The outcome of the case, I don't really go into the details of the case to save the time, but the outcome of the case was widely seen as a success for climate litigation because it brought changes to the German Climate Protection Act. So, for example, we had the adoption of an intermediate reduction target of 88% by 2040. So that was very progressive for Germany. And also it brought forward the German climate neutrality target deadline from 2050 to 2045. So seeing from what I just said, this is a significant success for climate change litigation. But then we have others who have criticized the same judgment for having limited impact in practice. For example, Janika Jan has written papers on that. So in fact, in Germany, administrative courts have had difficulty to rely on the judgment of the Constitutional Court to restrict projects that have negative climate change impact. We have seen that in cases regarding the extension of motorways or LNG terminals. So this in itself tells us that climate change is very complex, and adapting and taking any mitigation measure requires significant changes in the ways of our life. So because in today's life, every aspect of our life is connected to reduction of emissions. So if we want to consider any mitigation measure, then certainly it has impact on our daily life because it is too much interlinked. And that's exactly the case for the administrative courts in Germany, which they have quite difficulty to bring a balance on one side to protect climate change and as a result of that human rights, but then on the other side to restrict our fundamental human rights. So this dilemma makes the difficulty for the court to actually take actions as we want in practice. So from seeing it from this perspective, then one could say that, okay, since the judgment has a very limited impact in practice, then it's really not a success, but it's a failure. But then this will be also quite simplistic to argue, to say that, okay, since only the judgment had a limited impact in practice, then we should not consider that the case in itself was a success at all. And so to elaborate on this notion, we can take a framework that discuss the notion through two different lenses. First, we can talk about direct impact, and second, we can talk about indirect impact. So direct impacts are the court rulings, whether it's a positive or negative, legislative changes, or indirect impact. Most importantly, I think in climate change litigation is public awareness, civil society mobilization, which I will elaborate on that in respect of the judgment of the European Court of Human Rights in Lima Senioren case. We all know that the European Court of Human Rights ruled that Switzerland violated its positive human rights obligation under Article 8 of the European Convention on Human Rights due to not sufficiently complying with its positive obligation to adapt and effectively apply regulations to mitigate the effect of climate change. So among other things, the court ordered new climate legislation with quantified GHG limit for Switzerland. It orders Switzerland to develop a carbon budget based on the best available science. Seeing this is a significant success. We have seen from looking at that, it tells us that the case in itself is a success for the climate change litigations or for litigants. But then on the other side, someone could come and to say that actually for the litigants, the case was not success at all, because simply the elderly woman, the litigants, their victim status was not recognized by the court. It was the applicant association which was recognized to have standing before the court. And then we already see that how complicated it can be, the notion of success in climate change litigation. And that's why I believe that we should look into a broader perspective that could tell us what we mean, what we expect from climate change litigation. So if we look at the response of Swiss government in the aftermath of the judgment, we could see that Swiss government was very skeptical, was very resistant against the court. It accused the court of overstepping its competences. It accused the court of being too activist. It accused the court of breaching the country's sovereignty. And so even then, both chambers of Swiss parliament, they adopted a resolution recommending the government to not abide by the judgment of the court. And elsewhere in the parliament, even we have seen that members of parliament who have been very insultive and mocking women for taking the case to the European Court of Human Rights. So, for example, a member of the parliament from the right-wing Swiss People's Party said, quoting, "Because they are a bit too hot in the summer. That's why they brought the case before the European Court of Human Rights." And that we see that such a tense political climate in Switzerland in aftermath of the judgment. everybody was skeptical whether the Swiss government actually wants to comply with the judgment, at least implicitly. But then we had public and civil society pushback. Civil society groups, public, they pushed back against the reaction of Swiss government. NGOs, legal experts, general public, they criticized the government. Media played an important role here through publication, reports, interviews. So they built a momentum of making pressure on the government to change its stance and policies. And that actually happened, that we have seen a shift in the position of Swiss government. So the government, in aftermath of everything, changed its initial position by submitting its action report to the Committee of Ministers. And beside the wordings of satisfaction, as was required under the judgment, the Swiss government also argued that now it has closed the regulatory gap of 2025 to 2030 by amending the CO2 Act, which was required actually by the court. So the government had a different tone this time. It rather pursued a more diplomatic language, said that, okay, I'm going to cooperate, we are going to cooperate with the Committee of Ministers, and we want to fulfill our obligation as required by the judgment. But then here again, we have seen how civil society groups and NGOs played an important role at this stage before the Committee of Ministers. We had so many NGOs like Greenpeace International, Climate Litigation Network, Swiss National Human Rights Institution, Applicant Association, and many other NGOs who they have made submission to the Committee of Ministers explaining why the Swiss action report fell short of implementing the judgment. And then, to no surprise, the Committee of Ministers also adopted a diplomatic tone. It welcomed the progress that Switzerland has made in implementing the judgment, but again stressed its key demand, having a quantifiable carbon budget or otherwise of national greenhouse gas emission limitation. So overall, we have seen here there is a significant shift in the position of the government in respect of this judgment. And I would say that this is mostly thanks to the pressure from the public and also advocacy from the NGOs and civil society groups. So this tells us that when we look at the outcome of the case, we should consider the broader socio-political impact of that case to actually better understand what we want or what we expect from a climate change lawsuit. In the context of Switzerland, even though that the elderly women were not recognized to have a victim status or standing before the court, but still it is elevated ways of them in climate debate. They are being discussed elsewhere as the model, so how to pursue climate change justice. The case itself sparked public discourse and advocacy. It has mobilized many of NGOs and civil society groups, and ultimately it led to a change in the initial position of the Swiss authorities, which is certainly very important. And domestically, the case inspired various stakeholders to follow the seniors' legal strategy. For example, we have farmers and farmer associations who have filed cases at domestic level, claiming that the government lacks climate laws and policies threaten their economic freedom and property rights. And the case itself also inspired climate change lawsuits in other jurisdictions. So for me, this is what we should really consider when we look into the success or failure, defining success in climate change litigation, because it is quite clear that no single judgment of the court can actually address the problem of climate change. But important it is, if we want to secure a lasting change, we need to have a society in which people are more aware. So altogether, court, they can create pressure by the judgment, but lasting changes depends on the public and civil society action to build political will on the part of the government. And I think this is how we should see the notion of success in climate change litigation. So this is all from my side, and I'm looking forward for any questions which you would like to discuss afterwards.
So thank you very much, Hazhar. being a former EU law professor, I should say that there are some comparisons with EU law that are very interesting. For instance, one thing that in common with between the Costa NL, the Van Genden laws, or the Frankovic case is that the applicants got 0 in those cases, but still they are transformative constitutional judgments in EU law. So perhaps more important than looking to the short-term enforcement of a judgment or to the request in specific case, it's more important to look to the goals and to the long-term transformative societal and regulatory transformations that come as a consequence of that judgment. Now, I will pass the floor to Montreal, where I see that Myrto is preparing. Yes, I think now we can see Myrto's presentation.
Good morning. My name is Mirta Ribavaro. I'm a doctorate student at McGill University Faculty of Law. I'm actually in the same program with Yuri, but don't worry. I'm going to be very brief. I'm going to actually
upfront decision has been wrong. You became the scapegoat.
No.
Can you imagine?
To lunch right after. So today we'll discuss my paper on climate change, novel legal problems, and how legal traditions relate to the solution of legal problems. I'm actually happy that my presentation comes right after Hazhar. I hope I'm pronouncing your name correctly, because in our papers we look at similar cases, so you have already some context on what I'm about to say. So climate change, we see that carbon dioxide emissions are associated with climate change, as the IPCC reports show. But climate change, it's not just disruptive for the environment, it's very disruptive for courts, as it creates novel legal problems which challenge current legal doctrines. So, for example, such legal disruption would be, we heard yesterday in panel 2, in your presentation, Maria raised submission regarding multiple causation and joint liability. Then in panel 3, in your presentation, Rachel raised some issues around climate harm and eco-justice. Today, in his panel, Lucas referred to the recognition of the right to a healthy environment and green remedies. But there are also other examples of legal disruptions, such as political questions doctrine and the separation of powers and all the discussions around that, how we use evidence in climate decisions, and general the use of science in climate decisions. But today, I'm wondering, how do courts respond to legal challenges posed by climate change? And more specifically, today we're going to focus on one specific legal challenge, governmental duties, and how do courts impose positive obligations to states. In order to answer this question, I'm gonna employ a trans-systemic approach. So buckle up, we're gonna travel together to Germany, Netherlands, Canada, and Strasbourg at the European Court of Human Rights. So most of these cases you have already heard. We're gonna have Uganda versus Netherlands, knowing part that the previous speaker referred to. From Canada, we're gonna have the environmental joiners, I hope I'm pronouncing it correctly, Laos, Mathur, and lastly, the Climate and Affairs at the European Court of Human Rights. All of these cases have similar issues. They basically address the augmentation in the carbon dioxide emissions and what role and what duties do courts have in order to mitigate the adverse effects of that such emission have into climate change. So starting with the civilian tradition, 2 cases here. As you heard from Emily yesterday in panel 3, in Urgenda, Dutch courts integrated international human rights law, more specifically Articles 2 and 8 of the European Convention on Human Rights, into domestic law in order to recognize a duty of care to protect Dutch citizens against the adverse effects of climate change and mandate the government of Netherlands to reduce carbon dioxide emissions by 25%. Then, as you heard from my the previous speaker, in Neubauer, the German Constitutional Court had a different approach. It confirmed that the state has a duty to protect, according to Article 2 of the German Constitution, but it did not impose any obligations. Instead, it found that the Klimaschutzgesetz, the law on climate protection, was inadequate to achieve the Paris Agreement targets and mandated for its amendment. The court, interestingly, also recognized a duty of protection towards future generations. We had a lot of discussions around that during these 2 days. On the other side, in common law, and bear with me because I'm a newbie to common law and Canadian jurisdiction, Canadian courts have been a bit more reluctant. So here we have 3 cases, environmental jointness, Lagos, and Martyr. This involved a discussion around the Canadian Charters of Rights and Freedoms, and more specifically, Section 7 and 15. They recognize that there is a climate threat, but they did not impose duties on governments. Actually, you have a bigger problem because for Canadian courts, climate change is too political and too vague for them to discuss directly. So we have to surpass that first and then go into having discussions about imposing duties. And then there is another discussion around positive and negative obligations that creates another legal barrier. Some scholars have proposed that a solution could be to apply the living thing doctrine to surpass this legal disruption. Turning to the European legal tradition and the decision that you've already heard in the previous presentation, the European Court of Human Rights recognized by using Article 8 that states have positive obligation to adopt and take measures capable of mitigating climate change. That's not the interesting part of the decision. I mean, it's an interesting part of the decision for me, but also if you go into the decisions like 200 pages, it's a very long decision, but the court spends a lot of time in the decision before going into the merits to have some discussions about Urgenda and Neubauer. So the court actually looks in other national courts' decision, very dominant ones. For example, Urgenda was a decision from 2021. Then we have Neubauer, in 2019. And then we had Neubauer, which was in 2021. And then Lima came in 2024. But we look that some scholars describe climate change litigation coming into waves. So Urgenda started the first wave, and then we see that there is that arguments that applicants use get gradually refined, and arguments that didn't play at first and were tested in the first wave, then they get better and they become clearer and more effective when we move to further waves. So it's very interesting to see how courts actually see the evolution of climate change litigation and adopt better solutions. So I don't know about you, but I really like tables and charts. So here I have employed a comparative analysis, which basically shows first that courts can effectively address the legally disruptive nature of climate change. And second, we can see some departures or adherences from the legal reasoning that do characterize tradition. And bear with me here, because sometimes when I go into and present my opinions about climate, about common law and civil law tradition, I get a lot of pushback. So generally, one could say that civilian traditions are more codified, more structured, not that creative. But we see Urgenda started the first wave from the Court of Netherlands, and Neubauer also talked about protecting the rights of future generations. On the other side, common law, which is, someone could say it's more flexible. You don't have a code. keeping you in a box, we'll say, but you have a president, and you can, like, since we see in Canadian courts, the ones that I've looked at, they're very reluctant and cautious. On the other side, we have the European legal tradition, and we can see that in criminal seniority, the court actually hears and gets a nice influence from national courts and applies that into a very influential decision that I'm sure a lot of courts will decide after. So that brings me to the observation that we have a climate change judicial dialogue, and we can use the legal solutions that some courts employ in other courts in order to create a common judicial combat against climate change. Armando previously referred to legal creativity and looking into other places to find solutions to the legal disruptions of climate change. And as promised, I'm in 9 minutes. And so we have established that courts have a key role in global climate action. And actually, as Lucas referred earlier, to advance the conversation and global response to climate change. And we can see that different legal traditions, sometimes they get blended and they can offer better solutions to legal disruptions. What the future hold, we can turn this into the discussion. What will this argumentation mean for reparations for you? And this concludes my presentation. Thank you.